The Supreme Court has handed a massive victory to college athletes in their efforts to receive fair compensation. The justices unanimously rejected the NCAA's rules limiting benefits colleges can provide athletes. College athletes may now receive payments for studying abroad, academic awards, and other miscellaneous items tied to education. It does not permit payment of salaries. The NCAA attempted to argue their rules are necessary to help consumers distinguish amateur athletics from professional sports. The court says the rules violate the Sherman Antitrust Act and the NCAA is not eligible for an exemption. For more, let's bring in Dennis Dodd in Overland Park, Kansas. He's a national college football writer for CBSSports.com. Dennis, welcome. It's great to have you with us. Give us a sense of the magnitude of this case and what it means for college athletics.
Tanya, this is huge. This is possibly the NCAA's biggest legal setback. The only one bigger would have been in 1984 in the Board of Regents case, which deregulated college football television. That led to the influx of millions and billions of dollars into the system as these schools marketed their television rights. And that's basically why we're here today. There's so much money in the system for the lawyers. There's enough money for them to sue over. And this antitrust case has been going on since at least the last 6 years with Alston versus the NCAA. And it's really a trivial matter. We're talking about the NCAA defending its rules that says players can't get postgraduate scholarships from schools as an enticement, internships that are tethered to education, but they took it all the way to the Supreme Court and lost by a 9-0 ruling. So the action itself is comparatively trivial, but the margin of defeat speaks volumes for the college model now. It is at risk. What is at risk is really the NCAA as a entity, a rules-making entity right now. But for now, these athletes have almost unlimited benefits going forward if you put this together with name, image, and likeness.
Right. So as you pointed out, this was a unanimous ruling, but a narrow one. Explain what exactly will change now in terms of the way colleges are going to be able to recruit athletes, for instance.
Well, because these are only tethered to education, and it's a very narrow list of items that the NCAA has said you can't have, that it really doesn't have that big an impact. It's the fact that they brought this all the way to the Supreme Court to appeal a lower court ruling. But it is such things as, look, summer internships, you can travel overseas, computers, stuff like that. So it isn't, you can't get the quarterback a new car because he lives 10 miles off campus and that's quote unquote tethered to education. No, it's very limited. So on its face, it won't be the benefits, but it's what's going forward with name, image, and likeness, which is likely to pass in the next few weeks.
Right. Well, let's talk about that, because that's really that would be the real big game changer, I'm assuming. What does this ruling mean then for that fight over players' attempts to profit off their name, image, and likeness, or to receive direct payments? And also, I want to ask you, where does it seem that public sympathy lies? Because I really felt like in this case, the public sympathy really does seem to lie with the athletes.
It is, because as I mentioned, it was such a trivial matter. And look, I think we were all surprised in the media that the Supreme Court even heard this case. At the time, you're sitting there going, okay, this is a conservative court from the previous administration. Maybe this is the court flexing its muscles and saying, you know, we're going to uphold NCAA rules. Well, then you had the hearing in March, and there was a lot of attacks from the judges during that hearing to the NCAA process. And you thought, maybe they are against this. But you didn't really know for sure until they rendered a decision like today. And I said it was very definitive at 9-0. But combine that with name, image, and likeness, which will provide athletes unprecedented access to benefits off the field in terms of endorsements, autographs, commercials, modeling opportunities, their own YouTube channel. The NCAA is going to allow this. What they can't get their arms around is when it's going to stop, how they cap it. And the only way they have that, Tanya, is with help from Congress. And Congress has already said there's a Commerce Committee group or a Congress committee working on a federal bill that will not be ready anytime soon that would regulate that. What today means, Tanya, is the NCAA as we know it, it no longer exists. It has enforcement properties, enforcement abilities, and they hold a heck of a party every March in the NCAA tournament. But that overarching big brother NCAA is now dead.
That's really interesting. I want to read from Justice Brett Kavanaugh's concurring opinion, where he acknowledged the importance of college sports in America, but suggested that a broader rebuke of the NCAA was necessary. Kavanaugh wrote, quote, "Nowhere else in America can businesses get away with agreeing not to pay their workers a fair market rate on the theory that their product is defined by not paying their workers a fair market rate. And under ordinary principles of antitrust law, it is not evident why college sports should be any different. The NCAA is not above the law." So to your point, it certainly does sound like this is the beginning of the end for the NCAA.
Yeah, I was surprised personally that Justice Kavanaugh was so enlightened on the matter, and he was so concise and really damning with his opinion. I go back to a couple of years ago, the Pac-12 conducted a survey, the conference, that said players spend 50 hours per week on their sport. Now, that answers the question, isn't a scholarship enough? No, not when they're working more than they would for a job and more than they do in their academics on their chosen sport. Tanya, legislation had to be passed that no practice would begin after midnight or before 6 a.m. You know what that means? That means there were coaches out there doing that. So this, in some small way, empowers the athletes even more. And Justice Kavanaugh laid it all out to bear. He didn't say they're employees, but it looks a lot like they are employees when what they're asked to do takes away from their academic enterprise.
And further, we all know how short an athlete's career can be. And sometimes for these athletes, their college years are the apex, you know, and why shouldn't they be able to cash in on that? And that's something they've spent their whole lives developing. So I think there's a lot of sympathy for the athletes there. Well, Dennis Dodd, thank you so much for joining us. We truly appreciate your insight.
Thank you, Tanya.